Next, we will hear proponent testimony from Spencer Cahoon. Welcome.
Good afternoon. Thank you, Chairman Manning, Vice Chair McCauley, Ranking Member Thomas, and members of the Senate Judiciary Committee for taking the time to consider this proponent testimony regarding SB 288. My name is Spencer Cahoon. I'm an Ohio resident and a 15-year criminal defense attorney. My unusual work has focused almost exclusively on incarcerated people in prison. I spent years working full-time inside the Correctional Reception Center and spoke to or with almost every incoming incarcerated person for roughly 2/3 of our state. I also spent 4 years acting as the first supervisor of the Prison Legal Services section of the Office of the Ohio Public Defender. Consequently, I have an unusual insight into what incarcerated people are interested in. Based on my experience, including countless conversations with people arriving at or incarcerated within the Ohio Department of Rehabilitation and Corrections, I can tell you firsthand that earned credit is a topic of great interest. The expansion to 15% credit will act as an important incentive for incarcerated people to engage in risk reduction programming that will help equip them with the tools to succeed in free society. Earned credit serves a number of various important roles within our system. First, there is a rehabilitation and recidivism reduction role. In that role, rehabilitation, in the criminal context, is helping people with a history of harmful behaviors to find a way to succeed in life without harming others. The without harming others element addresses potential future crime, recidivism. Education is one of the strongest predictors of reduced recidivism. Other studies have noted as well the impact of certain programming on reducing recidivism risk. While not every person who is incarcerated will self-identify their need for education and programming, we can all agree that encouraging them to engage in impactful programming reduces the risk to all Ohioans by reducing future crime and preventing people and organizations from becoming victims. Expanding earned credit promotes engagement with education and programming that leads to behavioral change. It has been said that the best apology is change behavior. Expansion of earned credit will help motivate people to engage in the changes that are critical to making amends to prior transgressions and moving forward successfully. Additionally, there's a role in prison behavioral management. Because ODRC can remove earned credit when a person has conduct issues within the prison system, credit, once earned, provides a strong motivation to follow the rules and maintain good behavior while incarcerated. The greater the amount of credits, the greater the incentive. Expanding earned credit will provide the ODRC with greater leverage to help maintain safe and orderly institutions. This creates an environment that makes Ohio prisons safer places for both prison staff and incarcerated people. That, in turn, improves ODRC staff retention and satisfaction, while simultaneously creating an environment that is better suited to rehabilitation for incarcerated people. Finally, earned credit allows us to target incarceration. Incarceration is expensive in Ohio for the people incarcerated and for local communities. Expanding earned credit targets the people most prepared for successful reentry and allows them to reenter society sooner. This policy helps to assure that our correctional spending is focused on the people whose actual behaviors pose the greatest risk. I wholeheartedly endorse the core changes to increased earned credit. Given the harm and cost reduction benefits from earned credit, I would also encourage amendment to expand coverage further to all 4th and 5th degree felonies, which would match the bipartisan recommendation of the Ohio Criminal Justice Recodification Committee. That committee included, amongst others, prosecutors, local and state law enforcement, correctional staff, and local and state elected officials from both parties. Eliminating the restrictions in the earned credit statute for people serving non-mandatory 4th and 5th degree felony sentences would bring our earned credit statute into agreement with our demonstrated community view of what makes sense. The current 4th and 5th degree felony earned credit exceptions focus on crimes where the victims might be particularly sympathetic. And certainly compassion for victims of crime is essential in our society. There's always a tension between the incarceration-focused justice for current victims and rehabilitative-focused protection to prevent future victims. The expansion would not change sentences imposed. It would only allow release in cases where the incarcerated person has demonstrated commitment to learning and change combined with proven behavioral records in prison. This change could also save $42.8 million over a 10-year period from the avoided yearly incarceration costs. These savings would be entirely based on earlier earned credit releases of people serving sentences on the lowest 2 tiers of felonies. People whom we predict, after programming, would be less likely to reoffend compared to their peers. Given the history of bipartisan and cross-disciplinary support, this change would be relatively uncontentious. Regarding the committee's earlier question on judicial release, it can go either way. So it is a both-and situation when it says that a person will be judicial release ineligible. Now, obviously, there are people who are statutorily ineligible for judicial release. However, it is not uncommon for that to be a negotiated term of the plea, that someone will not be considered for judicial release. It is also not unheard of for a judge to just say that they're not going to release that person on judicial release. One might suggest that's bad practice, since someone who comes in front of a judge 5 years later may look very different than the person who's in front of a judge today. Nonetheless, all of our judges across the state, as elected officials, have very different interpretations of how best to fulfill that role. And all those interpretations are accepted because we are a local home rule-based state, and that is the way it will remain going into the future. I would note that well over 90% of cases, more accurately about 95% of cases in the criminal justice system resolve in pleas. Consequently, generally when you see no judicial release, that would have been something that was added with the plea, although even in the cases of pleas, judges are not bound by what is in the plea suggestion to the judge, and a judge can add additional terms or come up with something completely different than that recommendation that's made. In conclusion, I hope that this bill and the potential amendment to expand earned credit garners your support to better incentivize people in doing the work necessary to make our state safer. Thank you for your time and attention to this impactful area. If there are any questions from the committee, I would be happy to address them.
I have a question about the judicial release aspect, and I think I was following you there. So if it was agreed upon that there would be no judicial release, if that judge, for whatever reason, is termed out or is changed for a different judge, would that new judge be able to go against that plea agreement, I guess, and grant judicial release?
So yes, when there's the term no judicial release, it is not a binding term because it is always at judicial discretion because the circumstances can change, and that's not something like a sentence that is imposed at sentencing, even if it's in the sentencing entry. And I've certainly seen cases where people have applied for judicial release despite being told by their judge, prosecutor, or both, that judicial release would not be granted. So a future judge could grant that even if the original sentencing judge said that it would not be granted. However, as has been stated by other people testifying, the future judge is in a worse position to understand the facts surrounding the case. So there's a very strong incentive for a future judge picking up a case from a prior judge to go with what was written in the file from the prior judge who had a more complete understanding of the facts around the situation.
That's what I thought. I appreciate that. And you didn't really testify to judicial release. So do you think the earned credit aspect of this bill is, I guess, a greater importance than some of the judicial release aspect?
I wouldn't say it's of greater importance. Both are important. Just as a matter of limited time and attention, I didn't take the time to prepare testimony on both judicial release and earned credit. I think earned credit, particularly if it's amended in the way that was recommended, would be more impactful to a larger number of people in prison. As we've heard testimony, because of the ultimate judicial discretion in judicial release, even if judicial release is expanded, it will remain to be seen whether judges take advantage of that. I was one of the many attorneys across the state who filed a number of judicial release requests during the height of COVID for people who seemed to be at particularly high risk. And I had that same experience of both I and my staff having the vast majority of those judicial release requests denied. Even one of the hearings that was granted ended in a denial where the judge said he wouldn't cut just a few months off the person's sentence, which had been a multi-year sentence served without any problem just because of COVID.
Ranking Member Thomas.
I got a question on this, the earned credit. Now, I think the previous testimony was that it was Ohio ranked last in the nation in earned credit. Now, I remember during the RECOD, I was on the committee, and the director talked about a number of individuals that come up to his correctional facilities with less than a year of time still able to serve that's required. And he says he can't do anything with them in terms of putting them into programming like GEDs and things like that because they're there for such a short period of time. It seems to me that it would make sense that we don't send those individuals to the correctional facility, simply because we're not doing them any good. And that allows for those individuals who are there who do need the kinds of services. And why, is there any reason why we're last? I mean, that's just common sense, that if I'm told that if I come here and I got, say, 3 years, keep my nose clean, do what I'm told, get my whatever, that would be a huge incentive for me to straighten up. But you're telling me that there's no judicial release as relates to a plea bargain, so that individual goes up there without any hope of getting out any time other than when required. How do we fix that?
Well, one of the easier ways to do that is by expanding earned credit. Because unlike judicial release, which is at judicial discretion, earned credit is processed by the prison system. One other way that earned credit could be expanded, now, to jump back to one of your earlier questions and what you just said, how did we get here? Pre-1996, before we had definite sentencing, there was a much greater amount of good time, which was the predecessor to earned credit, that was available to people who were incarcerated. When truth in sentencing came in 1996 and we went from indefinite sentencing ranges to definite sentencing, the idea behind definite sentencing was that those sentences wouldn't be shortened at all. So consequently, earned credit was something that crept in after that as we started to move away from the original intent of truth in sentencing, or what we called truth in sentencing at the time. Today, you're absolutely right. There are plenty of people who spend a large amount of time in local jails before they are transferred to prison because of that large amount of local jail time, and that includes time that a person might stay in their local community while they're awaiting trial, and while that whole trial process is going through before there's a conclusion, before they even receive a prison sentence. If someone's only receiving a prison sentence of 9 months, but it takes 6 months for them to go through the trial process, they can get to prison and they can only have months left. I've seen people who've come to prison with days left. People who will be processed out the next day after they arrive. So that happens, and there are people with longer sentences who have larger amounts of time as well. But because of the limited amount of programming that's available, the limited number of physical seats, the prisons often don't prioritize people who have very short amounts of time or very long amounts of time for that programming. Thankfully, there have been some changes in the prison recently to introduce electronic tablets for people who are coming in, for everyone who's coming in. And it is the prison's plan, and certainly our hope, that in the future, programming will become more available through the use of those electronic tablets, so physical seats are no longer a limitation. That's not somewhere we are right now, and I can't say for sure that that's somewhere we will be in the future, but it's something that's certainly being looked at. But at the end of the day, for a number of these cases, it doesn't make sense to send them to prison. That's why the legislature passed TCAP, Targeted Community Alternatives to Prison program, to keep low-level offenders in their communities so they could maintain strong connections to family, to work opportunities, to other things, so that when they're released, they can more successfully reenter society. How we fix it is a multifaceted problem. Earned credit is one facet of that, and because the prison has the properly aligned incentives to apply that, and to help people get out more quickly because they are constantly dealing with overcrowding, the prison is a good partner in doing that. And I think other processes that allow the prison a more active role in that process, or even potentially that create another partner, another independent partner to help figure out when people are appropriate for removal, is another way we could approach that. But I think we're open to all ideas right now, and we're going to have to try a lot of things and see what works.
See no further questions. Thank you so much for your testimony.